Afternoon. Dean said 3M Candelaria, my classmates in this course, Doctrine of State Responsibility and COVID-19. Our group, panel 3, will be presenting Allocation of Resources. And that we will have 3 presentations this afternoon. Our group is composed of Judge Judy Galvez, Attorney Anthony Engenal, Attorney Amy C. Maranya, and Attorney Alex C. Tejerero. The articles on the responsibility of states for international wrongful acts, which is commonly known as the RCUA 2001, began by the International Law Commission in 1949 as one of the most important topics for the international law. It had already been discussed and left unfinished in the League of Nations Conference in 1930. A succession of eminent international lawyers, one of those is Robert Ago, together with William Riffigen, Aranjo Ruiz, and James Crawford, drafted them before adoption in 2001. The difficulty in negotiation reflects differing views and perspectives. General Assembly 6th Committee in 2008 decided to put articles forward as a convention in 2011. The rules on state responsibility may be described as secondary rules, and that every international wrongful act of a state entails the international responsibility of that state. One notable feature of RCUA consists in the absence of any requirement concerning fault or a wrongful intent on the part of the state in order to ascertain the existence of an internationally wrongful act. This does not, of course, imply that the element of fault has no place in the law of state responsibility. Rather, it reflects the consideration that different primary rules on international responsibility may impose different standards of fault, ranging from due diligence to strict liability. RCUA is concerned with a particular category of wrongful acts, and now termed as serious breaches of obligations under peremptory norms of general international law. As for the continued duty of performance, its status amongst the consequences of an international wrongful act is uncontroversial, as it is the principle that the domestic law of the responsible state is irrelevant as an excuse for failure to comply with the obligations flowing from its international responsibility for a wrongful act. We have serious breaches of obligations under peremptory norms of general international law, and that Article 42 defines in a rather narrow way the concept of injured state, while Article 48 is concerned with the invocation of responsibility in the collective interest, also by non-injured states. Article 42 provides that the breach of an obligation entitles a state to invoke the responsibility of another state when the obligation is owed to that state individually or in the context of multilateral obligations when such state is specially affected by the breach or is of such a character as radically to change the position of all other states to which the obligation is owed with respect to the further performance of the obligation. It should be noted that integral obligations are only those which operate in a strict all-or-nothing fashion, such as that each state performance of an obligation is in effect conditioned upon the performance by each other party. Human rights obligations are not, in this sense, integral, but may be better described as incremental obligations, and the failure to perform by one party does not relieve other parties from the duty to comply with them. The states entitled to invoke responsibility who are not individually injured by a breach are those described in Article 48, which lists states belonging to a group holding a collective interest for the protection of which the obligation was established, and every state seeking to invoke responsibility for a breach of an obligation owed to the international community as a whole. In this sense, the concept of international community relevant for Article 48 implies that this community does not consist exclusively of states and includes other entities, for example, the United Nations, the European Union, the International Committee of the Red Cross. International law is necessary to understanding how nations deal with resource issues, but is scarcely a sufficient element, and political, economic, social, scientific, or technological factors often also will play an equal or more important role. That's according to Builder in 1980. International law sets a framework for the international resource system by laying down certain fundamental rule as to which nation, if any, may initially own or control which resources. The international society, like most national societies, allocates rights of access to and control of resources through certain rules broadly analogous to property rules. International law usually regards a nation as having sovereignty or jurisdiction, the right to prescribe and enforce rules without outside interference over all conduct within its territory. Thus, a nation normally has the right to control every type of conduct, either by its own citizens or by citizens of other nations, involving resources within its territories. A nation's right to exercise jurisdiction outside its territory is more limited, particularly because it often must be balanced against the claims and interests of other nations. Because the concepts of sovereignty or jurisdiction over resources embrace the right to exclude others from access to or use of this. One of the most widespread and significant theory of international resource allocation is the principle that a nation may acquire sovereignty or exclusive jurisdiction over particular resources. The principle of national sovereignty and over resources generally has been held to mean that a nation having such sovereignty can deny all or some other nations access to or use of such resources. This principle also means that a nation can permit access and use to other nations on such terms and conditions as it chooses, for example, by entering concession agreements or trade agreements. This allocation of resources to various nations sets the stage for international resource policies and issues. Developing nations recently have urged, with some success, that developed nations extend substantial amounts of economic assistance to poorer nations. Such help may invoke the flow of developed country resources and monies to developing countries as gifts or loans at reduced rates, for example, agricultural commodities, under the US and Chinese agricultural surplus disposal programs, and of course, financial grants or even loans. We also consider here the Declaration of the Right to Development, as well as the Millennium Declaration. International law now recognizes that developed countries at least are obligated to extend economic assistance to developing nations, and an extensive body of rules, agreements, institutions, and procedures has been designed to facilitate and regulate assistance efforts. The vast and diverse networks of international rules, agreements, and institutions facilitating and regulating world trade in resources include the bilateral and multilateral commercial agreements for specific exchanges of commodities or establishing broad rules to encourage mutual trade and investment. We also have arrangements such as the General Arrangement on Tariffs and Trade for mutual reduction or removal of tariffs and our discriminatory barriers to trade. Agreements such as Loan Convention to foster trade among specific groups of developing nations, organizations of resource-producing nations such as OPEC, or of resource importing nations such as the International Energy Agency to strengthen bargaining powers or to deal with common concerns. Even before COVID-19 pandemic, many people around the globe understood that inequality was undermining their life chances and opportunities. They saw a world out of balance, they felt left behind, they saw economic policies channeling resources upwards to the privileged few. That is according to Antonio Guterres, the ninth Secretary General of the UN. The UN also urges states to leave no one behind and don't forget commitments in response to the COVID-19 crisis. Before COVID-19 pandemic, there was low economic growth. That puts a big burden. Working capital is much needed to accelerate growth. The onset of the pandemic resulted to slow all the more the economic growth. Under the Philippine setting, under the Duterte administration, let me mention that Duterte welcomed the UN's COVID-19 response and recovery fund designed to help low to middle income countries like the Philippines get back on their feet after the crippling blow of the pandemic. As regards vaccine, it was stressed by our president that an effective COVID-19 vaccine must not be denied or withheld from any country, whether rich or poor. He said there should be universal access to a vaccine and that it should be considered a global public good. He was very much worried and he warned that tensions between world powers could escalate to the detriment of countries. When elephants fight, it is the grass that gets trampled. He was worried that a world war between two countries with great military might could deteriorate into a real war of nuclear weapons and missiles. As regards migrant workers, Duterte called on all countries to protect the rights of migrant workers, especially as they lose their livelihoods due to the pandemic. He thanked governments who had given assistance to overseas Filipino workers and mentioned his administration's efforts to bring them home. Despite the pandemic, the Philippines still aims to reach the sustainable development goals set by the UN, such as ending poverty. Countries with limited resources still have an obligation to ensure an adequate standard of living. Even in times of crisis, governments are required to make every effort to meet this obligation with existing resources, including international assistance, and allocate them in a way that maximizes respect for human rights, including taking into account the precarious situation of disadvantaged and marginalized individuals or groups. States have obligations to use the maximum of their available resources to combat COVID-19 and realize the right to health. We also consider the permissibility of limitations and derogation of states' obligation in this connection. In short, in the context of COVID-19, states have obligations to prioritize and focus existing resources, whether financial, human, technological, or natural. They must also act to expand existing resources, whether through support from other states or private sources to ensure the realization of the right to health. The United Nations issued a checklist for human rights-based approach to socioeconomic country responses to COVID-19 to guide us in the maximum use of resources. When and if the answer to this question will be in the affirmative, then the country is having a human rights-based approach to socio-economic country responses to COVID-19. And the first question is with regard to access of resources without discrimination to food, essential healthcare, clean water, adequate housing, and essential levels of social protections. The same question was posed as regard the fiscal and economic reforms aimed to deploy maximum available resources, including through progressive taxation. If retrogression is unavailable, fiscal and economic policies should be aimed at ensuring that the retrogression is temporary, legitimate, reasonable, proportionate, non-discriminatory, and protective of the minimum core obligations of economic, social, and cultural rights, as well as consistent with the requirements of transparency, participation, and accountability as designed and adopted. It should also incorporate the human rights impact assessments, and they should address the issues that will arise therefrom. Are they geared towards ensuring that the national revenue is sufficient to ensure that minimum core obligations are met? Donors should refrain also from attaching conditions to their financing that could undermine the state's ability to respect, protect, and fulfill its human rights obligations in the allocation of resources and design of policies. Are these grants or loans from IFIs and donors monitored, including by NHRIs and civil society organizations, to ensure that they are used to address demonstrated needs with a focus on those most at risk of being left behind? In view of the COVID-19 pandemic, wherein almost all the countries of the world has been affected, even the countries belonging to this G7 or G20 group of nations have suffered not only in terms of medical and health issues, but as well as economic and social issues. Recession looms even in the strongest economies of US and China. GNP and other economic indicators are practically plunging and stock markets remain bearish. These developed nations who had been in the past supplied and shared the resources to the global south countries, whether they may have considered it their obligation or a treaty which they are party to, in the light of the pandemic justified in differing from, interrupting, or even deviating from its legal international obligations. With regard to the fundamental notion of wrongfulness, that is guided by Chapter 5 of Part 1, which enumerates circumstances of precluding wrongfulness, what in a forensic context would be called defenses, the legal justification that may be invoked applying RCWA or consent, self-defense, and necessity in relation to pandemic. The right to invoke responsibility is lost in two cases set out by Article 45. The first is where such right has been waived by the injured state, either with regard to the breach itself or some or all its consequences. The waiver has to be clear and unequivocal. And to conclude, everything we do during and after this crisis of COVID-19 must be with a strong focus on building more equal, inclusive, and sustainable economies and societies that are more resilient in the face of pandemics, climate change, and many other global challenges we face. Thank you and good afternoon.